Okay, ladies and gentlemen, we got a young man that's going to get us started. His name is Barry. Y'all know about Barry White, don't y'all? Mm-hmm.
I'm here, baby.
You know, he just wants y'all to practice something.
I'm waiting on you. Believe me.
He just wants y'all to believe him. Because he talks about telling me this and telling me that, okay? He just wants y'all to practice what y'all preach. Ladies and gentlemen, we're going to be pausing Barry White in a second because we're going to let y'all listen to a motion that I have been working on for other people. I've edited the motion, okay? But we're going to let the motion speak for itself. In order for y'all to hear it, we're going to pause Barry White. Barry, you know how much I love this song. When you came out with this song, I played this song day and night in my car. Everybody in the neighborhood got to hear him tell y'all to practice what you preach. But we got to let y'all listen to this because, see, some of you guys are wondering what to put in your motions to the court. Well, ladies and gentlemen, I'm going to show you two motions. I'm going to show you this one, and I have another one. I'm going to pause it, so I have to edit that one real quick, but I'm going to pause the thing so you can hear both of them. This is me saying enough. Tired of these stupid courts coming back at people acting like they're stupid and they don't know what they're doing, just putting words on a piece of paper. It's enough. Ladies and gentlemen, I've had enough. Been trying to figure out how to get around their stupidity, but we're gonna let y'all see how we wrote. See, what's happening in our adverse possession filings, what they're doing is they're coming back in the matter and they're asking for demurs. Ladies and gentlemen, if you meet the prerequisites for an adverse possession, they can't get a demur. You can't demur an adverse possession when a person has met their prerequisites. So that's how we kill the demur. That's why the first thing we start off with is that information, but pay attention.
Right to adverse possession, a common law right.
It's going to take a minute for it to catch up, y'all. Oh, you know what? I think it did stop.
Well, normally there are 5 prerequisites for adverse possession: that one be in possession of the property, that one had paid taxes on the property, that there be tolerable title to the property, that there be an enclosure around the property, and that one has made improvements to the property. But there are also 2 more prerequisites that I supplied the court: that I have been in possession of the property for the statutory limit of time, and that my possession of the property is not only open, hostile, and notorious. 2. Am I to understand that there is another party claiming standing in this matter? 3. The trustee has introduced himself into this matter, the same trustee who took the liberty which was not his to take and sold the property at sale while the property was being handled through bankruptcy proceedings, in violation of federal and state statutes. 4. The trustee draw and by and with the advice of counsel has presumed that the sole because I'm 70 years old that it can treat me as if I don't have any rights, because I have dual citizenship it wants to treat me as a second-class citizen, and I must object to that type of treatment here in the United States. 5. My home is protected by mortgage insurance. I paid the premiums of this insurance to protect me from my house being seized from me, and nobody has brought back into the fore. So I say, if you're going to introduce a deed of trust, that we will introduce the fact that my property had insurance to protect me, to make sure it remains mine,
That's definitely a speech recognition issue.
6. If you're going to introduce a promissory note, that I shall introduce, as is my right, the fact that I have the right to adverse possession, and my right to adverse possession is contingent on the fact as to whether or not there is a lien, a mortgage, a promissory note associated with the property, a lien, a mortgage, a promissory note associated with the property. 7. I bring to the court that the court cannot ignore my right to property, my right to file for adverse possession to property, my right to file for adverse possession. The court cannot block my access to justice, or to the administration of justice, or to equity and affirmative relief to property, my right to file for adverse possession. The court cannot block my access to justice, or to the administration of justice, or to equity and affirmative relief. 8. If another party is claiming standing in this adverse possession matter, then they will need to provide proof of such standing with respect adverse possession. I've seen no such proof on the record, and according to the law, undocumented, unverified proof cannot be considered by the court. 9. I must wholeheartedly continue my objection to any other party introducing what they claim is evidence, documentation that has no bearing on adverse possession. 10. This is a court of equity, and we must lend to equity. This court must grant my permanent equitable relief, as it sits in an administrative capacity to administer justice, and cannot deny me my access to justice and or administrative affirmative equitable relief. 2. Denial of due process. 11. The law is clear with respect to due process, so let me see if I can explain to the court how it cannot deny me due process of law, as it does not have the equitable authority to do so. 12. The opposing party seems to be introducing documents into an adverse possession proceeding claiming that it has met the prerequisites for adverse possession. 13. That at the time of the filing of the adverse possession it had met each of the prerequisites mentioned in paragraph 1 of this presentment. Yet they provide no evidence, no proof of meeting those prerequisites at the time of the filing of this presentment, and my understanding this correctly. 14. That somehow an adverse possession proceeding incorporates and not judicial process. 15. That somehow a learned student at law can circumvent the law and introduce foreclosure proceedings into an adverse possession proceeding. 16. That it was the intent of the legislature when it enacted the adverse possession laws for the state, to permit a party to circumvent the foreclosure process, and to misrepresent facts and adverse possession proceeding. Is this correct? 17. Adverse possession is defined in law and statute as adverse possession https://en.wikipedia.org/wiki/adverse_possession. Adverse possession, sometimes colloquially described as squatter's rights, is a legal principle that applies when a person who does not have legal title to a piece of property, usually land, attempts to claim legal ownership based upon a history of possession or occupation of the land without the permission of its legal owner. 18. From what I understand, there is nothing unique adverse possession process which prohibits me from making a claim on the property. Is this correct, especially in line and in conjunction with the fact that I have satisfied the 7 prerequisites? 19. Now the definition for foreclosure is completely unassociated with adverse possession, and there's nothing in the statute to combine the two processes and or procedures. 20. Be that as it may, the court must recognize that there exists a controversy and thereby cannot bring forth any claim for dismissal by an adverse party, because that would make it an adversarial proceeding. 21. We also bring to the court's attention that there has been no evidence placed on the record of the 7 prerequisites have not been met, and because no evidence has been placed on the record that is verified, validated, and/or certified, I must ask this court to recognize my right to proceed with my adverse possession claim and to acknowledge that such a right may be had in equity. 22. Further, I must ask this court to strike any and all documentation placed on the record by the opposing parties which does not relate to adverse possession, document their satisfying the prerequisites of adverse possession, and does not carry the full faith and credit seal as required by the Full Faith and Credit Act. 23. I also ask this court to sanction opposing counsel for its interference with the process, its intimidation tactics, and the other attempts to interfere with the petitioners.
Okay, ladies and gentlemen, let me make sure it says justice, access to the court, attempts to interfere with petitioners' access to justice with the process. Okay, ladies and gentlemen, let me explain to you what we're doing here. They simply put in a motion for demurrer and they introduce 45 pages worth of attachments. They introduced the deed of trust. They introduced the mortgage information. Sorry, I was trying to send, this is my cell phone telling me it can't send messages. Okay, letting me know the message is not sent. And that don't make no sense because I'm sending it. And it don't make no sense. It don't make nobody's sense. Nobody's sense. All right, but I've been having some problems as of late with sending messages, and I don't know what be going on, but I know it's getting on my nerves, my last nerve. See, that's it saying can't send the message to the person. So I'm gonna have to put y'all on pause for one brief second, okay? Okay, ladies and gentlemen, I saw the mistakes that the speech recognition had made, so I corrected those, and I went ahead and called the individual and let the individual know that I was sending the document to them again with the corrections, because The reason why I'm so cheap is because I don't do the spell checks. I just do the proofread. But when the person is not paying me, no, I give them the document. I give them the template. It's up to them to make the template fit their situation. Well, I don't know. Do I put this? And that's not my concern. How you put it. I'm giving you the arguments you're to put before the court. You have to take it and fit it into your case. That's what I've been doing lately because I don't have the time to manage people's cases. Why? Because they, pay attention, cannot pay me enough to manage their case. Let me explain so that some of you get it. In order for me to manage a person's case, I have to take total control over the case. That means I have to monitor the case. I have to be up on what the local rules are for the court, because each court has its own separate local rules that they want you to be apprised of and up on. And I can't do that because I have other things that I'm doing. I have other things that I must do. For instance, the case of the defrauded homeowners of America. The judge wants to be a judge, and I have to be careful because I'm representing a lot of people in that case. Okay? All right, let's get back to this so that we make sure we get this video done so that you guys are aware of it. And the other motion I will do on a separate video. There's no reason to do both of them now. Okay. We're saying because these idiots, the attorney is trying to do an in and around. He wants to bring in all the stuff regarding the foreclosure into an adverse possession case. Hey, bring it on in. Come on, bring it on in. If you want to bring all that in, then watch. See, my right to adverse possession. Hey, am I asking a question? Is my right to adverse possession contingent on whether or not there's a lien, a mortgage, a promissory note associated with the property? None of those things have anything to do with adverse possession. So we're saying, hey, I bring to the court's attention that it cannot ignore my right to property, my right to file adverse possession of the property, my right to file adverse possession. The court cannot block my access to justice or to the administration of justice or to equity and affirmative relief. You can't block me. I have the right to these things. And adverse possession only requires, the only way you can dismiss an adverse possession if the 7 prerequisites are not met. Okay? If another party is claiming standing in this adverse possession matter, then they need to provide proof of standing respecting adverse possession. I have seen no such proof. It's supposed to be not prove, but proof. So hopefully the person will watch this video because I told her to watch the video and she can correct the proof part on the paragraph number 8. On the record, and according to the law, undocumented, unverified proof cannot be considered by the court. The court cannot consider that which is not evidence. That's why we're objecting to all of that junk they put on the record. I must wholeheartedly continue my objection to any other party introducing what they claim is evidence, documentation that has no bearing on adverse possession. This court is a court of equity and must lend to equity. The court must grant my petition for equitable relief as it sits in an administrative capacity to administer justice and cannot deny me my access to justice and the administrative affirmative equitable relief. Denial of due process. The law is clear with respect to due process, so let me see if I can explain to the court how it cannot deny me due process of law as it does not have the equitable authority to do so. The opposing party seems to be introducing documents into an adverse possession proceeding claiming that it has met the prerequisites for adverse possession. That at the time of the filing of the adverse possession, it met each of the prerequisites mentioned in paragraph 1 of this presentment. Yet they provide no evidence, no proof, no meeting those prerequisites at the time of the filing of the presentment. And am I understanding this correctly? It's supposed to be a question mark. So paragraph number 3, you're going to add a question mark. Now, don't worry about it. If you don't add a question mark, it don't matter because we're going off of intent. That somehow an adverse possession proceeding incorporates, it's supposed to be non-judicial process. That's what it's supposed to say in paragraph number 4. That somehow a learned student at law can circumvent the law and introduce foreclosure proceedings into an adverse possession proceeding. That it was the intent of the legislator when it enacted the adverse possession laws for the state to permit a party to circumvent the foreclosure process and to misrepresent facts, and it's supposed to be in and, so in an adverse possession proceeding. Is this correct? Adverse possession is defined in law, and I give them the definition for adverse possession. Adverse possession has nothing to do with foreclosure, people. Pay attention to the prerequisites. It has nothing to do with foreclosure. All you have to do is meet the prerequisites. From what I understand, there is nothing unique adverse possession process which prohibits me from making a claim on the property. Is this correct? Let's put the question mark. I decided not to put a question mark, put a comma, but we're going to put a comma. Especially in line and in conjunction with the fact that I have satisfied the 7 prerequisites. Now remember, you guys go and you look and they'll give you only, you'll have to go back to the beginning of this video to find out what the 7 prerequisites are, but they'll only give you 5 prerequisites. They won't give you the full 7. There are 7 prerequisites to adverse possession. Okay? How do you know this? Because I've been doing this for a while. Huh? So shut up, go back to the back of the classroom. I done told y'all, go back to the back of the classroom and do the talking at the back of the classroom. Do not interfere with my videos no more. All right, number 19. Now, the definition for foreclosure is completely unassociated with adverse possession, and there is nothing in the statute to combine the 2 processes and or procedures. Foreclosure and adverse possession are 2 separate processes. They cannot foreclose on a property in adverse possession. Although they're doing an adverse possession, they cannot bring forth foreclosure proceedings in adverse possession. Be that as it may, the court must recognize that there exists a controversy and thereby cannot bring forth any claim for dismissal by an adverse party because that would make it an adversarial proceeding. We also bring to the court's attention what we're saying is, you idiot, you have a controversy. You cannot dismiss it. You've already identified that there is a controversy. Once you allow the adversarial party to come in and introduce evidence to the contrary, now you have 2 conflicting groups. So we're just giving them the basics, the fundamental principles. We also bring to the court's attention that there has been no evidence placed on the record of the 7 prerequisites, or excuse me, no evidence placed on the record that the 7 prerequisites have not been met, because no evidence has been placed on the record that is verified, validated, and or certified. We got to do this. I got to add this by the opposing party. Okay? I must ask this court to recognize my right to proceed with my adverse possession claim and to acknowledge that such a right may be had in equity. Adverse possession is a common law right, okay? It is also a statutory right. It'll tell you that right there in the code. Furthermore, I must ask this court to strike any and all documentation placed on the record by the opposing parties which does not relate to adverse possession. Document there satisfying the prerequisites of adverse possession and does not carry the full faith and credit seal as required by the Full Faith and Credit Act. Also, I ask this court to sanction the opposing party for interfering with the process. Yeah, because they knew the law. They introduced this stuff on purpose as a tactic for its intimidating tactics. Another attempt to interfere with the petitioner's access to justice, access to the court, access to their right under common law. And let's go on. Access to the court must be equal. I am not being permitted equal access to the court, and I must object. Why? Because the court must give equal access to justice. If they don't, they violate public policy. I am not being permitted equal access to the court. I must object to the court trying to hold me to a more stringent standard than an attorney. I must object to the court not reading my pleadings with, yeah, I was supposed to be liberality, but we're going to say liberally, ignoring my intent. The opposing party has been trading my property on the open market as a part of an agreement and has never given a single portion of the dividends and or the interest in return for my benefit and or to my benefit and or I don't don't know what this was supposed to be. Or attempted to apply such funds to the balance of any principal as agreed. All right, that takes care of that. If this court were to allow them to introduce that information, then this court must allow me to have the account fully audited so that I can prove that they have no standing. Let's do that. I do here and now demand the court allow them, the opposing party, to introduce the evidence of a deed of trust and or a mortgage and or any notes that I have the right, or excuse me, demand, okay, this is supposed to be, if the court allows the opposing, then it's supposed to be, then I have the right to prove that I permitted the trading of the property on the market and that I have not violated the terms of the agreement. We'll make it into a mortgage issue if they want to. That the monies received as a result of the trade were supposed to be applied to any monies they were claiming is owed and or due. So it's not his owed, but is owed. And I'll be sending a copy of this edited document to the young lady. You see, the problem is that the court allows them to introduce a deed of is that supposed to be if, and this is supposed to be opposing party. Well, it said them originally because I was just speaking into the microphone. Yes, ladies and gentlemen, everything you're reading is what I was saying into the microphone at that very moment. So this is coming straight from the dome, not from me reading somebody else's document. You see, the problem is if the court allows the opposing party to introduce a deed of trust, a mortgage, a promissory, not commissary. Let's get rid of something. And I know I'm gonna have to correct it. No, that's the wrong spelling anyway. Give me my correct spelling. I tried to take commissary and make it into promissory, so apologize. Then it must recognize the securities associated with that matter. This will become a securities issue and not an adverse possession matter. You cannot mix the two. However, if the court allows that information to be introduced, then I must hereby demand the court issue subpoenas so that I can subpoena the accounting to prove that they had no standing, that they have been fully paid. I could have put they've been fully paid, but they have been fully paid. And that each of those documents are nullities as a result of them receiving the full payment as agreed. Okay. And as mentioned, according to the March 9, 1933 Act of Congress and the Congressional Records of the 73rd Congress for the first session of Congress, all properties in America is owned by the state by virtue of government, and that we are still in the current national banking holiday economic emergency, which makes the accompanying documents that they presented government obligations. We got to highlight my government obligations. taking this matter outside the scope and jurisdiction of this court. Either way, if they are allowed to introduce such evidence, I'm allowed and permitted by law to bring forth a challenge to that evidence by asking them to bring forth their preponderance of evidence, which would mean they would have to show an accounting and not just documents claiming something exists without proving of the fact that the existence of said something actually exists, i.e. the ledgers to prove that they indeed possess a debt. Give me 1 second. Are owed a debt or are entitled to the repayment of a debt as being an obligor. Okay, so this is a simple document. This is responding to a demurrer. You want to bring forth a demurrer, you want to get rid of my case. Well, the first thing we're saying at the beginning of the case, pay attention. We give them the 7 prerequisites. We say that you can't dismiss this because we have brought forth all of the prerequisites for which we have the right to bring forth such a case. You can't do that. You must sit up here and let this case go through. This is an adverse possession. If they're making a claim, then they have to do so appropriately as permitted by statute. That's what we're saying throughout the whole document. Ladies and gentlemen, this is our responding to a demurrer by an ignorant attorney who thinks he can mess with us. All right, have a good day. We'll speak to y'all later. Just giving y'all the facts, ma'am. Only the facts.